Go live. Good morning. Welcome to Merlin Law Group's first virtual event. Today we're going to be going over a couple different topics. One, the new legislation in Texas, as well as hail damage and how you can get your claims better. First, we're going to introduce Chip. Mr. Chip Merlin
we're going to be going over a couple different topics.
The founder and president of Merlin Law Group. He's a national authority on bad faith and has served as the vice chair for subcommittee on property insurance law for the American Bar Association. He's a long-standing commitment to serving policyholders in their disputes with insurance companies, specializing in commercial and residential property insurance claims and bad faith. I also want to introduce Renee. She is our new attorney out in Houston, Texas, and is our second panelist who hails from Texas. She's recognized as one of Texas' most passionate and dedicated attorneys with nearly 2 decades of experience under her belt. She's helped assist those affected by Hurricane Sandy and beyond. So I would like to start off talking about the new bill in Texas, and I'll have Renee give an overview on that bill.
Hi, Will. This is Renee. We're kind of getting an echo here, so I'm going to talk over. There's like an echo. I'm not sure if our viewers can actually hear that or not, but I'll try my best. To talk about the hail bill, some of you in Texas or have heard of the hail bill or blue tarp bill, but it is House Bill 1774 and Senate Bill 10. And this last legislative session, it was a hot topic on how catastrophe, nature-related or weather-related events would be handled here in Texas. And it's going to be in effect on September 1st. So this hail bill is what it's known for, applies not only to hail, but it applies to forces of nature and weather-related events. So that would be wind, that would be a wildfire, that would be flood, that would be rain, anything related to forces of nature. Foundation claims, plumbing leak claims, and a fire loss not related to weather would not be covered by this new language on the September 1st bill. But it has a lot of detailed, specific terms and provisions that everyone needs to be aware of, not only policyholders, but public adjusters, and attorneys out there as well, because there are strict notice requirements that must occur now prior to filing a lawsuit. So if anyone has currently a claim that they are working on, that they are at an end with the insurance company or in dispute as of now, it is critical to get those cases in the hands of an attorney if you are at a standstill with the insurance company and you've done all you can to try to work out your claim because of the statute becoming in effect on September 1st, 2017. Would you like me to go over some more provisions in here, Mitch? Well, I'll continue on. So first of all, the notice letter, you're required to submit 60 days prior to filing your lawsuit a notice letter. And in that notice letter, it must be detailed. We've gotten a lot of questions over the last couple weeks regarding who should send that notice letter. And the notice letter is not something that a public adjuster should send. The way the statute is written, it is written from the standpoint that this notice letter would be sent pursuant to the statute prior to filing a lawsuit. So at that time, typically there is an attorney involved, and it will be a detailed notice letter that has a statement of the acts or omissions giving rise to the claim. You will have to name the people that you intend to sue or the parties that you anticipate adding to the lawsuit, as well as a specific amount of damage on the covered property. So you have to have your cost of repairs specific and detailed in the notice letter, as well as your attorney's fees incurred to date. So it must have a detailed analysis of basically your attorney's fees that are contemporaneously held at the time, as long with your cost to repairs the property and anyone you intend to sue. So that is a very detailed letter. That is something that a public adjuster would not send. It is something that an attorney should send for the policyholder. That is one of the most important provisions of this statute. The second, once a notice letter is sent out to the insurance company by an attorney or a policyholder, the next thing would be the insurance company has can ask for a reinspection, and they must do so within 30 days of receiving the 60-day notice letter. So they have to ask for a reinspection within 30 days of the notice letter. If they do, you must allow an inspection to reasonably occur, and they will tell you what type of inspection that they want. After that time period, the 60 days has passed, you are allowed to pursue your lawsuit against the insurance carrier. There is another provision in the policy, or not the policy, excuse me, the statute that allows an insurance company to accept liability and responsibility for the adjuster if they would like to, if you want to sue the adjuster and they don't want you to sue the adjuster, they can assume liability for that person. And if they do, then you are not allowed to sue them in a lawsuit. They can make that election pre-suit, but they can also make that election in litigation. So if at any time in litigation, the insurance company decides to assume responsibility for an adjuster on the claim, then the case would be dismissed with prejudice. So this will cause some issues in regard to where your case ends up, whether it's in state court or federal court. The additional thing is, under the new statute, it takes what we all know to be the Prompt Payment of Penalties Act, 542, which is the current statute, of 18% penalty, and it reduces that. So now there is no 18% penalty come September 1st. That penalty will drop to a floating penalty where 5% will be added to whatever the current finance code interest rate is. So that could be anywhere from 8-9% at the bottom number, all the way up to whatever happens to be the interest rate plus 5% at the time. And the last thing that's very important to understand is your notice letter that is sent pre-suit can be used in front of a jury later on at the time of trial. And if they choose to do that, you will have to be able to talk about how you came about your damages in your notice letter, and you have to live with those damages at the time you try your case. Your cost to repair and the damage that you actually seek in your notice letter will be the judgment to which your attorney's fees is measured by at the end of the day. So attorney's fees will be reduced by a prorated portion depending on what it is that the jury awards compared to the notice letter that you sent. So again, it is critical that the notice letter be pretty much accurate, right on point as to the cost of repairs and your attorney's fees at the time you write the notice letter, because that will be something the jury can see at the time of trial, as well as your attorney's fees will be determined by that. So that is kind of the highlights of the bill. There are many other details within the bill, but the thing to remember is if you have questions on whether the statute's going to affect you or not, or if the certain terms inside the statute, you need to get to a knowledgeable attorney that is familiar with the bill and the statute to be able to navigate those waters.
So what should public adjusters be doing prior to this bill going into effect?
Well, what they need to be doing, it depends on the stage. If right now they're currently working with the insurance carrier, if they are at what I said, a standstill, where they have a disagreement or a dispute with the insurance carrier that seems to be dragging out, or there seems to be delay on the part of the insurance carrier in paying the claim, then they need to advise their client as to their rights. And the fact of the matter is that this bill is going to take into place September 1st. And if they would like to have their lawsuit governed by a statute that's currently in effect, more pro-consumer policyholder, then they need to find an attorney quickly. But they still need to handle their claim the best of their ability, as obviously in good faith with the adjuster and the policyholder, but they also need to be mindful that September 1st, the law does change and it will affect Texans policyholders, both residential and commercial.
Okay, we have a question from Paul. He says, how do you think the HB 1774 will impact the teeth, so to speak, of a public adjuster, knowing it will be harder to litigate disputed claims? I always thought having a solid TDI statute and attorneys to endorse them deterred carriers from delaying, denying, and defending valid claims.
Well, the problem is this current statute, or the one that we have now, is a pro policyholder statute, pro consumer. It has teeth to it, like the 18% penalty that exists today. As of September 1st, that changes. It is not a pro policyholder insurance statute. In fact, it is a pro insurance carrier statute. And with that, the teeth, which is the 18% that allows an insurance carrier, basically reminds them that they need to pay on time. They need to do a prompt payment and an investigation. These are things that are lessened because with the penalty dropping from 18% down to 8%, that is going to change the way that insurance carriers do that. And I think that what we're going to see when it unfolds in September 1st and claims that continue on is you probably will see a lot of carriers try to invoke appraisal, as well as request multiple re-inspections of the property prior to litigation, as well as they might try to delay the claims a little more. I hope that doesn't happen, but again, it is a pro-insurance insurance carrier statute as opposed to a pro-policyholder statute.
Okay, another question coming from Stephen End. What is the single most important thing a public adjuster can do in a hail claim to avoid the courtroom?
I'll take that.
Yeah, go ahead, Chip.
I'll go ahead and take that one because I know Stephen and stuff, and and this can vary from person to person. But my first recommendation to all public adjusters is be prepared, and by that I mean know your loss. Be ready to demonstrate the scope of the loss and the reasons why a particular methodology of repair or replacements can be necessary. You need to be able to show and prove the damage and provide that to the adjuster. I think that is absolutely, you have to do that. Then you get into a big disagreement depending upon who you talk to. I have some public adjusters that then say, we even provide our estimate at that time. Some public adjusters say they absolutely never provide the estimate first. And I've heard it both ways. The people that provide the estimate first, especially if they have a good professional working relationship with the other adjuster and they believe that there's not going to be a problem with respect to the scope and methodology of repair. So there's agreement on that, believed by them giving the estimate to the adjuster for the insurance company. It's going to speed things up. And typically what people say, if you agree upon scope, you agree upon the methodology, and you agree upon that there's actually damage right there, price is a real easy thing to get agreement on. There's some other public adjusters that say, no, I like to get their estimate in first, and then we only provide it to them afterwards because sometimes they come up with a higher price than what we do. I've heard that happen, and be that as it may, I think there's a disagreement though. But the first thing I would say, the very first thing you have to do on hail damage is, where's the damage? Show it. Discuss the repair methodology and try to get agreement on scope. But you better know your case down pat and be able to explain it to them and show them. Because if you can't show them, all kinds of problems are going to happen. They typically start calling out experts, and everybody knows what happens after that on a hail damage claim.
Okay, another question here. Are the changes going to diminish the Merlin Law Group's interests in doing business in Texas? And will your firm and should others have sort of a sliding scale based on experience of a carrier for your proposed attorney's fees and to give proper notice?
So I'm going to go ahead. Can I go ahead and answer that? Well, at least the first part, and I'll let Renee follow up on the second part. But you know what? As soon as this bill, I saw it, I said, you know, and I've said this public to everybody, I think our law firm is going to make more money after the passage of this bill than what we did before. And that's because I've always said, I want us to be a firm that's going to work on the cases, make certain that we vet cases, take good cases. And I don't care if they're small or big. And I don't know where that thing came from. I mean, I've sued CNA Insurance Company over $46.75. And I don't mind that. And talking with Renee, because I know that she has the same type of philosophy I do. You know, any good case that we can take, that we vet first. And if the insurance company agrees with us after we write all this stuff down and pays the claim, we're still going to make money on. I do think, just like Renee said, there's going to be some delays and things like that. But if anything, for a firm like us that knows what we're doing, and now that I've got Renee in the firm with her team and we're building even more people in Texas, I think that, as I said, we're going to make more money after this thing. I don't think it's good for the policyholders. I don't necessarily think it's good for the public adjusters. But I think our law firm, unlike any other law firm, including the insurance defense bar that seems to be cutting out their, they want to get rid of the litigation. They make money on the litigation too, but they also seem to be the first people to the trough to back up their insurance companies with this bill. We're going to do just fine. So I think that was the first part of the question. And the second part, Renee, I'll let you answer.
Yes, I think that the key is obviously vetting your cases and making sure that your cases, that you have claims that you can stand behind, and that's what you should do anyways. And I think that there are firms that have stood the test of time, that know what they're doing, that care about the policyholders and put the policyholders first and try to make it right with the policyholders. And that's one of the things that Merlin Law Group does. And the fact of the matter is that the attorneys that have been doing it the longest and the ones that actually have studied the bill, have argued the bill, have testified on the bill, that know this bill, those are the attorneys that are going to be fine come September 1st. The ones that actually care about the policyholders and actually care about the changes in the law to know what that means and how to navigate the waters after that. But the key is vetting the cases. And if you vet your case and you understand how much it costs to repair the property, and you have experts that are knowledgeable in their field and experience and are able to help determine those values, then your notice letter should be pretty close to what you think that cost of repair is at that time. And do I hope insurance companies are more able to resolve these cases pre-lit? I hope that, the intent of the statute is, to try to get policyholders' claims paid timelier and quicker and more efficient pre-lit, but only time will tell if the insurance companies change their ways and if they actually are going to resolve cases before a lawsuit is filed, or if they're going to use this to their advantage and continue to take their positions on denying claims. And if that's the case, then you're going to have to litigate the case, and you're going to have to work up that case appropriately with the right experts in the field that know what they're doing. And then when you go to trial at the end of the day, then you're going to take it to the battle and take it to the mat. And with that, your attorney's fees, whatever they are, however they are, will likely be justified because of the work that you had to do in order to get the right result for your client, what they deserve under their insurance policy.
And a follow-up to that is, do the attorney's fees have to be approved, and by who?
You mean approved pre-lawsuit or did they say in their question? Well, let me answer it twice.
They did not specify.
In your notice letter that is sent, an attorney would send a notice letter pre-lawsuit. That notice letter has to have your attorney's fees incurred to date that are basically something reflected in a contemporaneously kept time record. So that is what that measuring stick would be in your notice letter, whatever they are as the time of that date. When you're in litigation, obviously, after lawsuit, when you have attorney's fees, that's going to be governed by case law in Texas, which is the Arthur-Anderson factors. And those are factors you would have to put on before a jury. It's very detailed, very specific. And if you prove those factors to the jury, and a jury determines the award of attorney's fees at the end of the day.
Hey, Renee, there's a follow-up question to that. I got a message from Dave Skipton, a public adjuster. He asked, how will the new statute affect bad faith damages?
The new statute is the only thing that's going to be affected in the sense you can still get punitive damages under this statute. You can still have all the causes of action. You still have breach of contract. You still have good, common breach of good faith and fair dealing. You have, if you have a fraud claim, you have a conspiracy to commit fraud in the non-disclosure. Extra contractual still exists. You can still get punitive findings in a knowing violation if you find one against, a jury determines that. The thing that is reduced is the prompt payment of claims penalty. And that is the 18% that existed, which everybody knows that statute to be, if an insurance company came back and underpaid a claim, whether it was a penny or whether it was $100,000 or more. If they underpaid the claim, then under the current statute, there was 18% penalty and attorney's fees you would get from the insurance carrier. The new law, September 1st, reduces that penalty down to a floating type of penalty, which is basically looking at the finance code at the interest rate and adding 5% to that. So that is going to be drastically less than 18%. But if you do have a failure to pay promptly, or you have a violation of 542, you will still be able to get a penalty and your attorney's fees under September 1st statute. It just will be less of a penalty.
Okay, and looks like the last question we have here is, does the effective date of the HB apply to existing current claims, or is it retroactive?
It is not retroactive. So what that means is, though, it's as of September 1st, it goes into effect September 1st. So you have to have your lawsuit on file. So right now, if there's a claim that exists today, and the claim is going on right now from a storm that happened 2 months ago, let's say, it's when you file. So September 1st, this goes in effect. If you file a lawsuit after that, it's based on the filing of a lawsuit. So there are claims currently being adjusted with dates of loss that are a year ago or 6 months ago or a month ago. If those dates of those claims look like they are not going to be able to be settled pre-suit, as in pre-September 1st, if you are at a standstill right now on a claim and you anticipate you will have to file a lawsuit, then you are going to want to try to get your lawsuit filed before September 1st, because it is based on the filing of the actual lawsuit. And come September 1st, to be clear, after that time, you will have to send a notice letter 60 days at least before filing your lawsuit.
Okay. We're going to now move on to hail and appraisal issues. And I'm going to ask you both some questions, as we have a lot of questions to cover. First, what are some effective strategies that adjusters can use in order to make their hailstorm evaluations more accurate?
I'll go ahead and start that. And for first of all, when you talk, it's a hailstorm. It's always remembering, we go through this a lot. It's not just the hailstones that are hitting it, it's especially the wind. And many times we find the wind does more damage than the hail stones. But so typically going through, you've got to show damage from one or the other. And if you're going to do that, because that's what the insurance companies almost always doubt, and what we always talk about is getting great meteorological reports that are going to show without a doubt that the hail fell in this particular area, how big it was, and then what the wind speed was as well. So start with strong meteorological data. And the second thing after that, we try to find videotape, photographs, and whatever else we can possibly find, eyewitness testimony, everybody else in the world that is around in the area, to show not only does the theoretical meteorological map show you had this, but the eyewitnesses on site took videos, took photographs, they have evidence. And it's because what you want to show and get the insurance company off their, well, geez, is this really hail damage? Do we have big enough hail, fast enough winds to have some type of damage there? That seems to be the very first fight that we have in all hailstorm claims. Thereafter, then it gets into, well, how do you go about fixing it? And again, when we get involved in it, it ends up getting experts, whether it be a roofing expert, roofing consultants, manufacturers, representatives. We have engineers to get involved, but we try to find the very best people that we can, and literally invite them to go out and meet with the insurance companies, individuals, if it's pre-litigation, to see whether or not they can be made an agreement. And for a public adjuster, I strongly do everything you possibly can to try to get the claim settled without going to an attorney. That sounds kind of wild in a way for some public adjusters, but I think it's the way your client would want to be treated. I think we should try to avoid litigation. You should try to do your job. And then last ditch effort, if you have to, then go see an attorney. That doesn't mean you can't consult with an attorney beforehand about what's going on, because there's very valuable rights that might get lost. But I do think public adjusters should go through those steps first, with the insurance company. So show the damage, get a scope methodology of repair that's backed up with experts, Use your eyewitnesses that you can the best, because insurance companies inevitably won't be doing that. And after you've done all that and they still won't listen to you, that's many times that you have to go give us a phone call.
And how should the public adjusters deal with the matching issues when they're evaluating their claims?
That's a really good question. So long as you don't, first thing is you've got to read your insurance policy and take a look and see what the insurance policy says about matching. Our blog's pretty blunt about matching, and I'll talk a little bit about Colorado. I'll let Renee talk more about Texas, because I think Texas has a different standard and a much more stringent standard with respect to matching. But the whole matching concept comes up in the thought of, boy, you've got damage done to a particular part of the building, and you have undamaged part that if you fix the damaged part, it looks different than what it was before. And it's typically for most buildings, it will have some market value component to it if you fix it that way. The second part, many times we find, it's not just market value, but really you have to match the two things. If you get experts that will come out and talk about it, Chip, you can't lay this brand new stuff with this stuff right here, and they have typical reasons why you can't do it, because of especially manufacturers' recommendations. And one of the biggest things that I remind everybody in the code, manufacturers' recommendations or suggestions are requirements on almost every single building code. In other words, it's illegal to build it outside manufacturers' recommendations or suggestions. And that sometimes that gets lost, and many times I find that the contractors, especially with the insurance company, don't go back and look at the manufacturer's recommendations with respect to rebuilding things. And as soon as you get to that, you get completely away from the whole matching issue. But if you have a matching issue, I find that typically, at least in Colorado, it's and we're very strong about this, that so long as you have any type of component part that really does matter, especially with market value, because there are some cases that talk about bringing a market value, it's different the way it looks. You should get paid for it in Colorado. I don't know necessarily if that's going to be true in Texas, because there's some really bad cases out in Texas that I'll let Renee talk about right now.
Well, I think the thing in Texas that, the most important thing is to read the insurance policy, because in Texas, especially post December 5th, 2015, a lot of carriers changed their policies here in Texas. And Texas has what is a file and use type of state. They file their form with TDI and they can start using it. But a lot of the major carriers and some of the smaller ones, when you go to TDI, you can research this information and it will show you the type of policies that have changed and the language in it. And what you'll find is that most of the policies and the insurance carriers have written to where they do not pay for matching. But matching, when I look at a roof, I'm looking at a roof. Matching, you can drive around anywhere in Houston and see a lot of roofs that have color different types of patching. You can see the new and the old right there. But it's a deeper analysis than that. You need to look at the whole of the roof. There is arguments to be made about brittle testing and seeing if the age of the roof, is it too brittle in order to repair? If it is too brittle in order to repair, is a replacement necessary? Sometimes you have to look at that. Just like what Chip said about manufacturing recommendations, they do matter. If you look at the GAF guidelines, if you look at whether there's a warranty on that roof, and is that warranty now going to be void if there is a patch done to it as opposed to replacing it. Things that go into a little deeper of an analysis, what you will find is it simply isn't a matching dispute. It is more of a roof integrity dispute. And is this roof even able to be repatched or repaired, or does it have to be replaced? And good luck finding a roofer that's going to do a partial patch and warrant that work. Most of the times they're not going to do that. So you do have to do a deeper analysis. Texas is not favorable as to matching types of arguments. Most of the policies actually specifically say in the policy that they will not do matching, and it's just not part of the policy. So read the policy, make sure to look at that in detail. If you have questions, then obviously get advice from an attorney that understands those policies.
There's one last thing on that. Will, there's one last thing I'd like to suggest. And, on our blog, we've written about matching. I think I did a search, about a month ago, and it comes up like 33 different times we've written about matching. And there's even a paper that we have that if you go to our blog, you can bring up those written by a Rutgers law professor with United Policyholders that goes state by state by state, every single state. And any state that has a particular rule on matching, it's listed right there. So a public adjuster can quickly get to our blog and get an answer on a state by state basis, absent some policy language, what the status of the law is with respect to matching in that state.
So now we're going to get into an issue of new versus old damage. And say the public adjuster is working on their claim, and throughout the claim process, a second storm hits. How do they go about handling that?
Well, I'll give you some pretty good advice to begin with. So yours is a little bit different. You start off, and then there's subsequent damage. Typically, that means the public adjuster, and that's the reason why you go out and you get your videos and your photographs, and you document that damage as much as you possibly can, because you can't help Mother Nature from coming around the second time around. If Mother Nature comes around a second time and you have another hail damage, you've got a problem if you haven't documented how much damage you had from the first one. And it's a lot bigger if you have a brand new insurance company with a different insurance policy. So, because then you get one insurance company saying, oh, it's from a previous loss. And of course, the other one saying, no, it's from this one over here. So getting your documentation down with respect to physically scoping out how much damage you had from the first one and the comparing the two is important. If you have one insurance company, it's not as hard because you can claim, just take a double deductible on it. You bought both damages, so to spec. But that's the issue with respect to, you're already on a loss, and then you have another damage claim or another hail damage claim, and that's different than the situation of, we just found out that there was hail damage 2 or 3 years ago before we even took a look at this roof. And that's a much bigger situation. I don't know if that's the next question or not.
Well, there's a question actually from Neil McLaughlin. He says he's had an issue with a refusal of proof of loss and a refusal of a second inspection based on additional damage.
Okay, so I know Neil. Hey, Neil, first of all, let's talk about proofs of loss, all right? A properly filled out proof of loss that states an amount and it's technically proficient, the insurance company truly only has 2 options, okay? Number one, they can only reject it if there's a technical deficiency in the proof of loss. And they should spell it out and ask you to do it again. When they say we reject the proof of loss for anything other than you haven't provided documentation that's supposed to be part of the proof of loss, the person hasn't signed it, you haven't given us the policy number, you haven't put the interest, blah, 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 whatever it is, that's the only reason for a real rejection of the proof of loss. Because then what it triggers under the policy, almost every single property insurance policy says within 30 to 60 days after we get the proof of loss, we're going to tell you if we're going to repair or we're going to pay. And what that means is most insurance companies have an option to do the repair. So you put in a proof of loss and that triggers their option at that time. The failure to indicate how much, if they agree with it or not, doesn't mean that the insurance company owes what's on the proof of loss. A lot of public adjusters ask me that question for some reason. That doesn't mean anything. It just means that they've breached the insurance policy by not telling you if they're going to pay or they're going to repair. Now, an insurance company that disagrees with the amount that you claim should indicate that they disagree with the amount that's being claimed, but still indicate how much they think is owed and actually pay that amount right away because they at least agree with that amount. We typically don't find insurance companies do that. They want to get leverage and they want to hold back money from the policyholder and get you to take something less. But I could talk for a half an hour on the proof of loss. But so when you say refusal of a proof of loss, just remember it's either rejected or it's accepted. And it should only be rejected for technical reasons. So the second part of the question you had is the refusal. I think you wrote down here, what happens for refusal of a second inspection based on additional damage? Yeah. So and I'll talk about that in Colorado, and I'll then let Renee talk about it in Texas. But in Colorado, obviously, that would be a unfair claim practice. An insurance company has an obligation to go out and do a full inspection and not delay matters. So that if you're providing them additional information, an insurance company refuses to go out there, and I have no idea why they would do it, but you're providing them additional information, and it could be all kinds of things. It could even be during the repair process. As a matter of fact, hey, we found some uncovered damage. It was hidden and stuff like that. Look at what we found, as we're going through this, that it's going to cost more, to go get it fixed. Insurance companies should be out there right away with respect to that. There's no if you think of the obligation of good faith and fair dealing, they should be concerned about making certain that the policyholder is getting the full amount of money that they need to whatever benefits are owed under the policy as soon as possible. And it shouldn't be the type of thing that they're ducking the payment because they're refusing to go out and gather more information, which would show that they owe more money. That's, especially in Colorado, going to get a lot of insurance companies in trouble, and you treble damages out there still right now. So if that happens, that's absolutely wrong. And if you have a good claim out there, the insurance company could be a lot of trouble for not going out and doing the inspection. Having said that, I'm going to go ahead and Renee talk about Texas.
Well, from what my understanding is that, I mean, I can't stress this enough. If you have a situation in Texas where you have additional information on the claim and you've submitted it to the carrier and they're refusing to go back out on a request for reinspection, then that is something you need to document your file on. Ask for the basis. Ask them why they will not come out. Ask them, you know, I've sent you this new additional information. I'm requesting that you come back out to reinspect, and see what their basis is for not coming out. Because if they don't come out, then you're left with no choice at that time. Then you likely are going to have to litigate that matter if they're going to refuse to come out and do a reinspection of the claim. However, most insurance carriers are usually going to have a basis, and you may not see it because it's in their claims file and they've likely written it down in their claims file somewhere. It could be the fact of, if you supply additional information from a non-credible source, for example, they may believe that the bid that you received or something that you got from a certain contractor or an estimator, they might believe that person not to be credible, and therefore it doesn't warrant them to go out and reinspect. And you're not going to know that unless, of course, you ask, and they may not tell you that anyways. But that might be something internally that they make that decision based on. If you haven't complied with your policy provisions, and that is, you know, allowing them, if you allow them to do an inspection and then they requested additional documents from you or requested additional documentation and you haven't provided that to them, then they might stand on that and say that they don't have to go back out there because you haven't complied with your terms under the contract and the policy. So my biggest advice on that is there's two. Number one, read the policy, make sure that your duties after a loss and you have done everything requested of you from the insurance company. If you can, that is a reasonable request that they've asked. That's number one. Number two, document your file. If you've asked for that and you put it in writing, give that information that you're saying is additional information to the insurance carrier, ask for a reinspection in writing. If they refuse to respond, ask for a basis. And if you've done all you can, then it's likely time that you're going to have to, if you want to seek something more, you're probably going to have to see an attorney.
One last point on that before I let, hold on, Will. One last point before I let people go, because I think Renee hit it on the head. And I also want to make this warning to everybody. Just because I said it would constitute bad faith or the lack of good faith, truly what it is, the lack of good faith, doesn't mean that public adjusters should be writing pontificating letters to the public adjuster. As a matter of fact, I would use the golden rule. Having said that, I know if I say that to a number of public adjusters who use the aggressive approach, they're never going to stop. But when you read it back to a jury or a judge, it doesn't come across well at all. And one of the things that we find is that you can be very professional and still be very pointed in your letter, especially if you use the golden rule. In letters that say things like, I've got to explain to your customer why it is that you won't come back out and reinspect it. And I have no idea. I'm just looking for an honest explanation so I can tell them why you won't come back out. And I would, you know, I've even put that, I suggest you have a change of heart, reconsider this, and please come out. If you'd like to give me a phone call, we can discuss this. Anything nice to move the matter along with respect to the claim, as well as you know, for the policyholder's sake. You'll come across looking a lot better. And sometimes I even see, oh, we know what they're trying to do. They almost consider a nice letter a setup letter. And the next thing you know, the insurance adjuster's coming out there. We're not going to let that happen to you. We will go do the reinspection. So, you know, please remember that. Always be professional. It's a big point that we've been making lately. I should never see a public adjuster's file with a letter going to the insurance company saying you're acting in bad faith. That doesn't do anything. Point out what they're doing and say you can't understand why you would ever do it that way. It makes no sense, you know, and then use the golden rule. Why would you do it that way to your customer? And that's just my suggestion for helping
Yeah.
document that file properly.
And can I make another suggestion here? I think this is important. A lot of insurance carriers are using the policy provisions and terms as in requesting documentation. They are using that as a catch net, a huge net, basically throwing out their net there like a broad brush. It is a tactic that these insurance carriers I've seen over the last 16 years when I started doing this 16 years ago. I've seen now they're more putting the onus and the burden on the policyholder and the policyholder's advocate or public adjuster saying, I need all this information from you before I can come and do my investigation. There is a fine line there because there's going to be, they will use that. They're looking at it from a standpoint of if this case goes into litigation, if it goes into lawsuit, what are we going to paint on the other side? They're going to paint the picture that they requested all this information from you and you never provided it, or you failed to provide all that they've asked for, and therefore they couldn't do their investigation in order to get out of having to have a bad faith finding or breaching the contract or a penalty attaching. But that's why it's important when you write your letters and being detailed, if they're asking for documentation, send the information to them. But if you're not sure, send a letter that says, what information are you requesting? I'm not understanding. Can you please provide me a basis for this information? I've given you all this information on these occasions, and you can state the date, because that is a growing defense tactic that they are now doing. Because if you look at the evolution of policies in Texas, there used to be policies from big carriers in Texas that used to have as their duties under the laws, it would say that they would have to go out and begin an investigation and do a proper and thorough investigation. And now those words are out of the policies. If you look at those same carriers over the last decade, they've changed that to where some policies don't even say they have to do an inspection. It just says they will begin an investigation. That's it. So they're making it their burdens less, and what's on them and their duties less and less, and they're putting more of the burden of the inspection, the investigation, the documentation now on the policyholder. And that I have a big problem with, because when you buy an insurance policy, you are buying for protection and coverage of your property, and you're also buying a service, and that's a service of adjustment. So a lot of carriers, beware of that, but document your file. Help your policyholder and their insured by documenting your attempts to get this information to the insurance company, because I promise you, they will use that as a defense later in litigation against their own insured.
Okay, great. Our next question comes in from Eric Bowen out of Texas. And his question is, if his insurance claim is underpaid and the insurance company denies the appraisal process, what options does a PA have?
Well, that's interesting. In Texas, currently, appraisal provisions are favored, as in, after Johnson versus State Farm that came out back in 2009, I believe. In that case, obviously, appraisal is one of those tools that is used often, but you will see, again, that is one of the provisions that are changing in the policies of these carriers. So over the last couple of years, there are carriers that have filed different formed policies that we're beginning to see now in these data losses that are more current of how they want to do the appraisal process. But if he's triggered appraisal and the insurance company has refused, one of the first things to find out is why they refused. Make sure if you've invoked appraisal, did you appoint your appraiser on time? Did you tell them your appraiser's name in a letter? If you did, and they're just simply saying we refuse to go to appraisal, there must be a basis. See if their basis is their objection to your appraiser. Maybe they're not agreeing to your appraiser. If that's not the case, see if it's because they're denying it based on coverage. Is it a coverage dispute versus a loss amount dispute? Get a detailed, if you can, response from the insurance company. If they refuse to do that, then at that time, if you're a public adjuster and you're wanting to go to appraisal, you might have to make a determination. Is this something you want to put into litigation and have attorneys take care of that? If you've tried to get an appraisal, it's going to be hard to enforce an appraisal provision if they're refusing to go. As we saw in Johnson versus State Farm in Texas, they're favorable. But you have to look at the policy. If you look at Allstate's policy, for example, They have a very detailed appraisal provision currently in their policies that take away the ability to appoint an umpire by a court. Now it goes to AAA, the American Arbitration Association, all kinds of detailed parts in there. If you look at another carrier's policy, I believe State Farm's policy now does not allow you to invoke appraisal post litigation. So they don't allow that. So if you want to invoke appraisal, you must do it pre-suit. All these things obviously will be challenged at some point in litigation at some time. And until the case law basically talks about it, it's going to be things that are litigated later.
Okay, great. Next question. I know, Chip, you talk about overhead and profit a lot. We have a question coming in from Doug Waldy in Arizona. He's saying Allstate has a bad habit of not paying for OMP for damages that source from a hail claim, even when there is substantial damage to the structure outside the roof itself. Is there a potential for some type of mass or group action in hail areas where this is happening? For instance, the Safford, Arizona storm that happened in October 2016.
Well, there's always the potential for overhead and profit. The first, big case talking about overhead and profit that was a state Supreme Court case, not a federal case, was the Gilderman decision out of Pennsylvania. And indeed, it was a class action lawsuit. Many insurance companies that were not treating overhead and profit properly, if you go back 15, 20 years ago, were getting sued on class actions by class action attorneys. And some of the results were substantial, actually mind-boggling. There was a recent law review article that just came out this year by Missouri, the University of Missouri Law Review, and just giving the numbers of the hundreds of millions of dollars that are at issue with respect to overhead and profit. These can be big class action lawsuits. The problem is, since some of those lawsuits 15 years ago, many of the insurance carriers have now taken a position that it's not right because they get to go to appraisal. So when our law firms filed class actions, both in Florida and Texas, sure enough, the insurance companies, similar to arbitration issues, all of a sudden raise appraisals, a way of saying, well, you can't go to litigation. You have to first go to appraisal, which gives them an out from the class action lawsuit or substantially slows it down. So it's not as easy as an answer as to what it used to be, I would say 15 years ago on the class action front, and you have to take a look for it. Now, in Arizona is a great state. It's a great state with respect to unfair claim practices, and if the insurance company is doing things on a repetitive basis, it certainly would give rise to, and it's wrong, it would certainly give rise to the possibility of punitive damages in Arizona. So, Mike Poley, our team out in Phoenix, certainly would be interested in the Allstate, overhead and profit cases if that's what they're doing.
Okay, and should public adjusters make recommendations based on actual cash value or simply replacement costs?
Well, I could talk a little bit about that. I mean, the vast majority of all insurance policies that are replacement cost policies do require a determination of actual cash value. Not all. And I remind people that some insurance companies sell replacement cost policies that pay replacement cost right away. They go out and figure out what the theoretical replacement cost is. Here's your money. You don't have to do the replacement. You don't have to get a holdback or anything like that. But those policies are few and far between. Typically, most insurance policies have in the replacement cost provision a determination first of what the actual cash value is, and then the big debate, and I can go into that in just a little bit later, actually has to do with whether or not the depreciation of labor, should be considered. And I think we have a question later on that, Will, at the very end, and I'll talk about that at the very end. But certainly everybody should determine what actual cash value is on almost every single claim, as well as figuring out what the replacement cost is. It would be hard for me to imagine not doing it that way.
Okay, well, and what's the single most important thing a public adjuster can do when first meeting a company adjuster at the loss location?
Well, on a hail damage claim, I think I answered that. That was Stephen N. We already answered that, Will.
I'm sorry. There you go. What would you recommend to public adjusters to improve their standing as a professional witness?
I know. I can answer that.
Well, I'll see. Here we go. Renee's going to jump in first, and I'll listen to what she says, and then I'll give you the rest of the right answer.
Mine kind of is my rule applies to anyone. I think to be prepared and educated and knowledgeable about the laws that pertain to what you do. So that is the best way if you're going to, and you will find yourself at some point in time in a deposition, or you might be a witness in a case. But the people, I mean, you are who you are and be yourself, but be your best self. And what I mean by that is educate yourself, know the current laws and issues facing public adjusters, know the TDI bulletins that have come out that are applicable to you and the claims that you're adjusting, know any pertinent case law that comes out. Take pride in those type of things, know that inside and out, and be educated in that, in those parts of the law, because that is what you do. And I think the best witnesses are those that take those things to heart, that actually, whether it's reading on their own, whether it's going to courses, whether it's going to continuing education, whether it's being part of newsletters and emails and blogs and actually getting information from others in the group, educate yourself, give yourself knowledge, know the current issues facing public adjusters. That's what I think applies in any type of profession, but specifically will help you be a better witness and an expert and an advocate on your case. Chip, go ahead.
And I agree with everything that Renee said, and I think certifications mean a lot too. I'm a big believer that public adjusters should strive to get, if they can, the CPCU designation. And I know some people get upset because the institutes also have a specialized certification for public adjusters, which certainly public adjusters should get. But by getting either a CPCU or an associate in claims designation, an AIC designation, that shows something to the insurance industry that you cared enough about your profession to take extra training, go through the education of it, and then pass a test that very few people go pass. In the insurance industry, the CPCU is a calling card. You can go and take that anywhere and put it down. And most insurance companies tell their executives that want to rise up in the ranks to go get it. And so to the extent that you can go get it, you show it, you put it on your letterhead, it certainly shows that you care enough, you have enough interest in your profession that you're putting down that very strong designation. And I tell people all the time, what's the downside of going and getting it? Because people look on the other side of you as a notch up that you actually did it, and it will help your client get more money. It'll help you get more money quicker. And I'm not saying more money wrongfully. I'm saying more money because you have a stature and they respect more of what you do because of that education.
Okay, great. We have one follow-up question for Renee regarding the Texas House bill. And what they're asking is, will we be filing lawsuits separately if a client has more than one type of loss, like a sudden and accidental discharge and a hail claim, since the new law only applies to hail claims?
If you have a situation, that's going to be honestly a decision made with an attorney, and who, depending on who the attorney is, it's like a strategy call. If you have a plumbing leak case or a foundation case or something like a fire loss or a theft claim, something unrelated to a force of nature weather-related event, then nothing changes in the fact of this statute doesn't apply. So you could file your lawsuit instantly, or you could file it post September 1st first without sending your notice letter. Now, the notice letter requirement has always been there in the sense of, you know, under the insurance code, you're supposed to send a notice letter 60 days, but the remedy, if you didn't send one, was just an abatement of the case, and your case still was on file. So you could still go to mediation, you could still go do other things, your case was still pending in the court, it just was in an abatement period until your notice letter was sent. But if you have a dual causation case where you might have plumbing leak and then you have a roof claim at the same time, as to the roof claim, if it's from that force of nature, then on September 1st, if you have not filed your lawsuit prior to September 1st, on September 1st, you will have to send your notice letter 60 days pre-suit. If you did not, let's say that you ignored that statute and you file a lawsuit that has the plumbing leak in it and it has the weather-related claim, which is your hail claim, then yes, a court could, basically a defendant could move to sever and abate that case and sever out that claim, that's the weather-related, if they wanted to, or move to dismiss it until your notice letter has been complied with. So as opposed to it just being abated and still pending in the court, it would actually be dismissed by a court, and a particular a provision in this statute that is hidden in the language of the statute is a court can't even order a mediation to occur if that notice letter provision has not been complied with. So let's go back to Hurricane Ike, for example. In Hurricane Ike and in the hail cases down in the valley, there were standing orders in place that within 100 days of you filing your lawsuit, you could go and exchange information with the other side and sit down and try to resolve your case. Well, if you do not meet the notice provision and file your notice letter 60 days prior to filing your lawsuit come September 1st, guess what? You can't participate in those type of early mediation requirements because a court will lose their authority to make you go to mediation. So this notice letter provision is very strict in this statute. And I wanted to touch base. I answered a question, but I don't know if I made it clear enough earlier when you were talking about dates of loss. I believe someone asked if this is retroactive, and I want to be very clear about this. This statute does not talk about a date of loss. It is not one that says any claim that is made after September 1st is subject to this lawsuit, and every claim made before September 1st is not. That is not how the statute is written. It is basically saying if you intend to file a lawsuit, so let's say come September 1st, it's September 1st, you have a date of loss that's from 2016. You did not file your lawsuit prior to September 1st. Even with a 2016 date of loss, after September 1st, you will have to send a notice letter before you file that lawsuit. And that is not tied to the date of loss. It's tied to when you actually file your lawsuit. So my point is, if you currently have claims you are handling, you are going to have to make that decision as to whether or not y'all are at an impasse. If you are, it's beneficial to the policyholder and the insured to file their lawsuit pre-September 1st under the current existing law. There will still be cases, there will still be claims after September 1st. There are just a lot of teeth in this statute that have to be met, and there's a lot of pitfalls. There's a lot of hidden things in here in the statute that you have to know about if you're practicing policyholder insurance or a public adjuster after September 1st.
But Will, I want to remind everybody we now have 6 full-time living here in Texas attorneys that after September the 1st can hardly wait to dig into these things. We're not afraid of it, and Renee's going to be heading that up for us. So we're ready for it.
Okay, great. Last hail topic to talk about. With the rise of technology, what are some tools that adjusters can use to help make more sound hailstorm evaluations?
I don't know exactly what is meant by that, but I mean, there's all kinds of things that can be used with respect to it. One of the things that is being used that I find is drones, and the drone technology. I think the ability to take cameras up there that do various types of things, and I've seen a couple that are kind of expensive, but I think they'll pay for themselves, especially on roof claims. That it's going to make your adjustment a lot quicker. You're going to be able to digitize exactly what you see much quicker, and you're not going to have to get up on top of the roof that creates all kinds of problems. Insurance adjusters, I would include in public adjusters too, have a much higher incidence of falling off roofs or through roofs, and it's something to be concerned about. I've been taking these OSHA things lately. You really don't supposed to be up there doing an inspection. The inspections OSHA allows for is supposed to be like a 3-minute inspection. You guys are up there 3 hours at times, circling stuff and things like that. And it can be done with a drone. And I've seen some very effective mechanisms with respect to that. Also taking the moisture, test and things like that. All the camera equipment in the world and all that equipment that we used to do just getting up on hand, up on feet and getting up there, we can now do with a drone. So, one of the suggestions I've made, I think all public adjusters should consider going through that, the course of getting certified and all that, using it for business and buying the best drone they can possibly get. I'd also be wary. We finding the insurance company experts aren't exactly being honest about the use of pictometry and stuff like that, the Google Maps, and it can be very misleading how they go about doing that. If you have some problem, Christina Phillips just wrote a blog about it just last week, and watch out for that. I mean, there's a right way to do it, but there's definitely wrong ways to do it. What we find is most of the time the insurance company engineers, maybe because they're just ignorant, they're not doing it intentionally, giving them the benefit of the doubt, but they're not using the technology properly and giving wrong indications because of the pixels that change from the satellites way up there afterwards regarding pre-existing losses and things like that.
Okay, great. And in closing, regarding the House bill in Texas, what are your thoughts? Do you expect the insurance companies to push for this for all other types of loss in the future?
That'll be interesting. I think that, unfortunately, that's kind of where these things go is they first start out small and then it kind of widens, right? And then, but only time will tell. I mean, the thing that is really right now, it depends. Like if a hurricane comes post September 1st, which we all know in Texas, most of the time hurricanes hit, usually they're in September, then we might see a real problem here, because if what we had said in Austin when we were arguing against this bill is that with these provisions in this new statute that allow insurance carriers to accept liability on the behalf of adjuster in order to basically forum shop, to determine whether they want to be in state court or federal court, you might have a huge amount of cases in federal court, which always takes more time, always takes more money. It's longer, and federal judges will not like that. But you're really not going to know the effects of a statute like this until something on a large scale happens. And we've had a lot of changes post Ike. We've had obviously the TWIA, Texas Windstorm Insurance Association bill that happened after Ike. That changes the way things will be done in the future on those type of cases. And this is going to change a little bit also. But what's important to note is that the causes of action are still there. There will always be disputes between policyholders and their carriers. I would hope that carriers are trying to do the right thing and trying to avoid litigation and trying to make it right with their insureds. But the problem that I have here is with this new statute, there is no pro-consumer or any type of a pro-consumer provision in this statute. It's all pro-insurance carrier. There wasn't a rate decrease for homeowners or commercial carriers. And that's another thing we need to talk about. Everybody thinks residential, but this also applies to commercial. And if you can imagine, public adjusters are dealing with huge commercial claims where damages are ongoing, and you're going to have to be able to pinpoint exactly, almost at an 80% success rate or above, what the jury would award you in a trial as to your cost of repair and damages. And those damages could include business interruption. Those damages could include your cost of repair. That's where it's going to get really hard and difficult, is on a complex claim. How perfect can your notice letter be? And are you going to be able to live with that come time for the jury? Because that is something that the jury will see. So it's going to matter your experts, your assessment pre-suit, the attorneys that you hire, if they're knowledgeable about the case law and effects of the statute. All that makes a difference now. So it's only time will tell if these insurance carriers actually are going to do better by this new statute, or unfortunately, if they're going to take advantage of policyholders, and you'll see more denials and more disputes.
Thank you very much, Renee. And Chip, and in closing, I know you wanted to touch on an issue that's going on in Colorado right now regarding depreciation of labor.
Well, there's two issues I want to talk about in Colorado. The one, if everybody can go to my blog, you can read about the decision that came out by the 10th Circuit. There has been a trend for insurance companies to start depreciating labor. And it's a very, it's something that I was taught, never depreciate labor, absolutely never. And it was the insurance industry that really started doing this, and insureds then had to challenge them because insurance companies started doing various things, saying, well, we don't have to pay sales tax until it's actually incurred. We don't have to pay and put into the valuation of anything until things are actually incurred. From that viewpoint, why the heck pay them anything whatsoever until it's incurred, I guess. But most of the states have shut that down, but the one that seems to keep going now that does have some impact with respect to judges has to do with the depreciation of labor. Now, this is not a state court decision. It's not Colorado binding, and I'll point out how that can change. Sometimes what the federal courts say the law in Colorado is not what the Colorado courts would say if given the chance to do this. And instead of the 10th Circuit punting the issue, and maybe because the policyholder attorneys didn't ask them to do it, but it's really more of an issue of state law, whether or not the state of Colorado is going to allow depreciation to take effect. But at least a trial court judge, two trial court judges now, and a federal appellate court judge have said that you do depreciate labor in Colorado. So that's something to be wary of. My suggestion is to, because I've had public adjuster ask, well, what do we do now? And I said, well, yeah, I mean, you can make it so that you've got a depreciation without depreciating labor and one with depreciating labor, and argue with the insurance company as to which one's going to apply until we get a state court appellate decision. And the reason why I say that, probably the other big issue that's come up, and I'm just going to read a case. It comes from an appraisal, and there was a number of federal courts in Colorado with respect to appraisal that essentially said almost if you have any contact whatsoever with one of the parties from a prior relationship, you can't be an appraiser on the particular case. I mean, I had insurance defense attorneys coming up to me going, what's going on in Colorado? If that becomes the law, we're going to run out of appraisers because we have to go back and see. We'll never get another appraiser. We have too many appraisals going on. And if we have contact with them once, we can't call them again. And, I said, I don't know. I said, this is what's going on in Colorado. But there was I think a very well-reasoned appellate court decision that came down on July the 27th. And it's the Owners Insurance Company versus Dakota Station case. And I think it cleared it up quite a bit. As a matter of fact, it even allowed a cap. It allowed a cap for a 5% fee, saying that by itself doesn't mean that the person's biased. But I'm going to just read one paragraph from there because it completely this is said specifically, we disagree with these prior federal cases. And then it wrote this, and I'm just going to read it. The policy did not require the independence required of a judge, arbitrator, or umpire, talking about appraisers. It said both the appraisers in this case had pre-existing relationships with their retaining party. The respective parties provided in part the appraisal information relied upon, thereby necessitating contact with those parties. Honestly, if you're going to try to do an honest appraisal, you want to get as much information as possible from both sides, even the insurance company. I teach this. Why wouldn't you want to go get all that information? If you don't talk to the party, you might miss something, and heaven forbid, then people don't get paid what they're owed. So I think appraisers ought to be working really hard to find all the damage, talk to the parties, get all the evidence. Now we can get to the right stuff. But the federal courts almost weren't allowing them to do that. So this is really a good change. I'm going to keep reading it. Both appraisers knew an umpire would review their appraisals and select what the umpire found to be the more accurate appraisal. Under these circumstances, it's understandable that the appraiser, I'm not going to put the name in, may have viewed herself as an advocate, but that does mean that her appraisal was biased, dishonest, or purposefully inaccurate. As stated by the Iowa Supreme Court, appraisers do not violate their commitment by acting as advocates for the respective selecting parties. However, appraisers should be in a position to act fairly and be from suspicion or unknown interest. I agree with that completely. And I think that's how appraisal goes on in most places. And Colorado kind of got away from that for a period of time. We're going to see what's going to happen with more case laws that develops. But this is a very important decision for those of you who are in Colorado and were, geez, can I even become an appraiser up there? Is it worth? I've seen people say, forget going to Colorado. They challenge everything in the world up there and try to make you, because you knew somebody in a particular matter, out to be almost a crook, from it, which isn't the case whatsoever. So we'll see what happens on that decision. I hope it'll allow appraisals to go on much quicker and not get delayed and without being challenged all the time on one side or another. It doesn't mean necessarily, because I was thinking about that question that Renee asked, what happens if they refuse to go to the appraisal process? Oh my God, if they refuse to go to an appraisal process in Colorado, I mean, that's a delay. And typically if it's a delay and not done with some really good faith reason for it, like you didn't satisfy conditions preceding, things that Renee talked about, but they just are not going to go to appraisal after you demand it. I would suggest public adjusters might write one more letter. Guys, are you sure you don't want to go there? What's the reason why you won't go to appraisal? It's in the insurance policy. And if they refuse to do it after that, I think most Colorado attorneys are going to say, because of that trouble, damage, bad faith statute, go litigate the case. As a matter of fact, we've been saying that a lot lately. Go litigate. If you've got a strong case, go litigate the case. Colorado is a great state to go litigate insurance company cases if you have an insurance company that's not acting properly. You know, so I guess I probably said enough on that particular issue, but there's been one bad decision that came out on the depreciation of labor. We'll see how the state courts come out and address that someday. But there's been a real good decision with respect to appraisal that's come out that the state courts corrected the federal courts on. Thanks.
And Will, just so to everybody who wants to actually look at the statute, the House Bill 1774 or Senate Bill 10 of the Hail Bill, I wrote a blog yesterday. I think it was posted, The Truth About the Hail Bill. At the bottom of that blog, there are my email and Chip's emails on there, but there might be a hyperlink, I believe, to the Capitol webpage that actually has that statute, that if they want to read it, they can. It's very complex, but go ahead. And you can find that reference in that blog.
Well, you know, they're going to call my telephone number because I'm a lot prettier than what you are, Renee, right?
Yes.
All right. Thank you very much, Chip and Renee. Please feel free to send them in. We'll write blogs on the issues and make sure to get that out. If you don't follow our blog, please be sure to go to propertyinsurancecoveragelaw.com and sign up, as well as sign up for our social media, Facebook. Follow us to be able to stay up to date. And we look forward to sending a survey out to you to find out what you want to hear more about. And we look forward to seeing you all soon. Thank you.
Thank you.
Bye-bye.